Well, by this time, a lot of you people know, say, idea back one, na me pay ye pan, say, I like to read opinions from people, what you say, on certain issues. In fact, now I'm saying, okay, the na me pay a kinkain pan, a legal opinions, what you say, especially from judges and the likes. Na, many abo article be so, na article we a free. Platform be your friend no 233 legal. 233 legal. Now, if you understand 233 legal, if you understand what they are trying to do or what they are talking about, they want to talk about legal matters in Ghana. Now, they are putting an interesting an interesting spin on Kevin Taylor. The court case now Supreme Court abonsem neguno. And I want us to look at it. I want us to look at what they are saying, what you are saying, because it looks like a lot of people don't really understand the issue like that. Now, I think they took it from here. So this article was published yesterday. Now, Mamin Kinkai or say it has, by all accounts, been an eventful legal year. The suspension of a sitting Chief Justice and the attendant's legal challenges arising therefrom both before the domestic courts and the sub-regional court, the ECOWAS court, into a free Chief Justice no, aside. As equally noteworthy was the mid-year bar conference, which witnessed the passage of a resolution regarded by some as controversial. The resolution led to a cascade of divergent commentary concerning the constitutional processes for the removal of the Chief Justice and the role of the bar regarding same. And yet, the year also witnessed some commendable initiatives. The Ghana Bar Association's Young Lawyers Forum offered an important platform for junior members of the profession to share concerns with managers of the bar. And of course, one cannot ignore the Law Week celebrations across the nation. An initiative of the National Bar, this year's Law Week offered a forum to explore artificial intelligence and its attendant implications for legal practice. We wish members of the fraternity the best of the legal vacation. Now, to the major news item of the week. I think say it is a law platformer. News in Sensem, especially legal news. Now, or back Kevin Taylor the end or so. Now, let's listen. Or say, on 22nd July, the Supreme Court, by a majority 4-1, squashed the bench warrant issued by Justice Eric Chebafor for the arrest of Mr. Kevin Taylor, a Ghanaian broadcaster resident in United States of America. Taylor had been cited for making comments on social media in a relation to a case that was pending before the court, and that the said comments had disparaged the court and brought the standing of the court into disrepute. We all know this, the story to this point. Accordingly, Justice Chebafor, a justice of the Court of Appeal and sitting as an additional High Court judge, issued an arrest warrant for Taylor to show cause why he should not be cited for contempt. Anyway, now say Justice Tanko, speaking for the majority among others, indicated there was no due process in issuing the said warrant, thus the decision to squash same by Setuarai. I say it must be emphasized that the Supreme Court had not been called upon to determine the merit or otherwise of the contempt of court allegation against Kevin Taylor. The question of whether the alleged comments of Kevin Taylor constituted contempt of court and whether or not he is deserving of punishment remains undecided. And that's quite interesting, right? I remember say Emra, I don't know, but I think say we need some more clarification on this, because this is not the first time I'm hearing something like that. I'll explain so you understand. Emra and Eskumi Koforidua Court issue the arrest warrant. Oko Supreme Court ekoko squash ye no. Sorry, ekoko quash ye. Quash, and yes, squash, Mr. Mufanchemi. Our call ya okoko quash case ewo Supreme Court quash arrest warrant no egu no. I remember say that time no NDC lawyers be ebabonte beka say the substantive case no is still there. The fact that the Supreme Court quash arrest warrant no and interest say contempt case no yaboegu a arrest warrant in yaboegu but contempt no there still court no ebetumi action for contempt. I don't know whether you understand. That was what the NDC said. Okay. Inti ohe sa legal opinion we are the author of this article no is saying the same thing. Or see Kevin Taylor and anyone who has a different view can let me know, right? Or see Kevin Taylor case no ye issue arrest warrant. But arrest warrant na ye issue ye no. Ye see Kevin Taylor yenche nimbra nombra court ni nim ni emeche for contempt and I yembe di na for contempt. The nkrofo way can say China yesi yenchi Kevin Taylor mbra sa arrest warrant say mushan wo bebi a monche nimbra no. Yesi Supreme Court abo enu egu said abi muko shan wo bebi dia ma monche nimba. But say wono Kevin Taylor no be ko judge ni nim. Na judge na kwa ko di na asem the contempt case ne de eno no Supreme Court mbombu ye. Right? And I think say this makes a lot of sense. I don't know, but I think this makes a lot of sense because anyway, I'll see. Let me read it again. It must be emphasized that the Supreme Court had not been called upon to determine the merits. Inti Kevin Taylor de Assembly Court Supreme Court no. One fact case na nkwa that Supreme Court in him say contempt na kra no bogu dabi or the court Supreme Court say arrest warrant ni na bogu. Inti Supreme Court abo arrest warrant ni gu. But contempt ni de ye mbongu ye. We just say yakatre and say bia the Supreme Court judge don't be there. Yeah, ma me get talk no. Only in the history of this country. Ena afenyuma kendi case ekoto get talk no enim. Case the intia afenyuma kende ko get talk no enyo no he okoko ye different. Charlie. And then mami ye na nkrofo me so mo trese mami no a saint. Anyway. So basically that's that. And indeed and Mra be read the Supreme Court ruling no. Anyway, the Supreme Court on Kevin Taylor's own, we've not really had a ruling yet. But I think the ruling I read was on Kennedy Japan, and it was the same thing. Kennedy Japan so dear no, ye bo arrest warrant ni guye. And ye ka say onko judge ni nim ni enko di ni contempt case. Just that ye ka say judge fufro and the internal case no so, but yam free case no. Kennedy Japan dear no up till now yam free case no. What you say? Into here Kevin Taylor dear so it looks like it's going to go through the same route. It was the question of whether the alleged comments of Kevin Taylor constituted contempt of court and whether or not he is deserving of punishment remains undecided. It is said Kevin Taylor ye betching for contempt or dabino still and then ye undecided ye but arrest warrant ni ya boygu but still ye betumi achine for contempt. Basically that's what the article is alleging or saying. Also the Supreme Court was only essentially called upon to determine the propriety of the processes and procedure used by the learned trial judge in issuing the warrants of arrest. The court held that to the extent that the learned trial judge did not issue the necessary notices to be served on Kevin Taylor before the issuance of the arrest warrant on an alleged contemptuous act that had happened outside of the court, same was invalid as it was done without jurisdiction, breaching the hallowed or the Odi alterum partem rule. The legal effect is that only the bench warrant has been set aside and now has no effect. However, it is still within the rights or powers of the court or judge to proceed against Kevin Taylor on the contempt allegation afresh, albeit subject to the service of statutory required notices. So it means that the judge can still cite Kevin Taylor for contempt. That's quite interesting. So this is the legal opinion. I think say anyone who has a different opinion on this can let us know. Okay. This is quite interesting. One time, your comment box ni moment that's it. And the Ghana for bebre, yarea a queen, a stroke, diabetes, cancer, heart disease. Na sa yarea we ni na no. The underlying factor eye adia wo broni friend visceral fat. Now her screen is so we a doctor a website. Now what trust say visceral fat. Visceral fat wraps around your organs, creating inflammation and interfering with organ function. This fat causes a big belly. Now one thing about visceral fat and it's engrophobia Rebecca, oh ye benu me bibi drew ebema yefu atwe ye benu me drew ebema mefu atwe visceral fat no oboa obi obeka do so we draw bia obenum na wefu atwe no oboa because belly fat no e draw bia ni ho ebetumi ama na akofom. You only lose belly fat when you decide to lose weight. Na me meti he me obi a na first me obi belly fat no na me obi visceral fat no na me obi ena ende mini ohwa mefu atwe na enyama me ye no eye method bi a me friend no the WWE method. Me dey atro book no or comment box ni mu. So open book ni bi ato a eno ane se wa click comment box ni mu na tre se wa to book no. Ana screen so book ni din eye your action plan for weight loss. Na wa click na wa pe book no ato. Ye kan eduro eye duane a ye di. Obi a wobeka tro so ye pe eduro be ma yefu atwe bia no me se oboa. Mesrew eduro ye duane ebedi nti metre we duane a obedi ni na wo book nim ene nyama e wo se wo ye nti no get the book and then live healthy.